Thank you for taking time out of your day to come to listen to this event. We're very privileged to have Justice Joe Williams, one of the 6 serving justices on the New Zealand Supreme Court, with us tonight. He has a really long list of achievements, which I'm not going to go through, partly because I reckon there's a lot more to come. But I will just say that he was the chairperson of the Waitangi Tribunal before he was appointed to the High Court, then the Court of Appeal, and then the Supreme Court. And we are going to be talking a little bit about the Waitangi Tribunal tonight. It's customary that we start an event like this with an acknowledgement of country. That's a little tricky for us at the moment because the country on which this court building sits is subject to some claims in this court, but it is generally recognised that this is the country of the people of the Eastern Kulin Nation, and I can pay my respects to the people of the Eastern Kulin Nation and their elders and ancestors, and I can also acknowledge the challenges facing the Australian community in relation to how we deal with First Nations peoples, and in particular how First Nations peoples are treated by our justice system. Now, Joe, can I start by just saying, if we were in New Zealand doing an event like this, how would it start?
Would start with a mihi, with a formal greetings in Māori by whoever was chairing by you, and it would be immaterial that you're not Māori. And actually, we had a similar problem with disputes over the site of a court, over who was the traditional owner of the site of a court. Except it was more difficult. This is the Auckland High Court. We had a plinth set up, and upon it was going to be a statement about the traditional rights of a particular tribe. And then that issue came to court, so we had to halt the whole ceremony that was going to do that, so the whole thing could be played out. So I feel your pain. It's difficult.
Okay, so tonight we're talking about treaties. And as I've just mentioned, you held the position of chair of the Waitangi Tribunal for some time, in 2004. And just to orient our Australian audience about things, can you tell us about the function of the Waitangi Tribunal and its role its relationship to the Treaty of Waitangi?
So the Waitangi Tribunal was established in 1975, initially as a prospective jurisdiction. It's a standing commission of inquiry with recommendatory powers to the government about what should be done if and when the principles of the Treaty of Waitangi, park that idea, the principles of the Treaty of Waitangi were breached in relation to any law or action of the Crown or proposed law or action. So that brought bills into the jurisdiction of the tribunal, as well as policies that had not yet been implemented. That position remained from 75 through to about 85, primarily because there was no appetite to open up the Pandora's box of a truth and reconciliation process about what had gone on prior to 1975, all the way back to 1840. That mood changed in 85, and the tribunal was given retrospective jurisdiction, and essentially, really for the next 30 years, was the commission of inquiry into the process of colonisation, valley by valley, tribe by tribe. And it's just about finished that work over however long that period is.
And when you say finished the work because...
So it's inquired into the claims and issued reports, and or claimants have decided not to go to the tribunal but to negotiate directly without the inquiry. So what happens in the tribunal process is there'll be a process of inquiry and reporting that could sometimes take 3-4 years, and then a negotiation with the Crown on the basis of the report, albeit that the findings of fact are not binding on anybody. But some of the bigger, more organised tribes have tended to say, we'll go straight to the Crown and save the pain. because these sorts of inquiries are painful for the various groupings that come before the tribunal district by district, including the fact that they can test and create friction amongst claimants that if you can avoid, sometimes it's better to avoid. On the other hand, sometimes the process can be by creating a single enemy, the Crown, which the Crown is very happy to stand in as. Well, when I say very happy, it shoulders that responsibility, knowing that there is benefit in various communities within a district all facing a single counterparty and using that as an opportunity to create unity where it might not otherwise have existed.
Now, you asked us to, when we were listening, to park the concept of principles of the Treaty of Waitangi. So can we just deal with that a little bit? And I think probably, again, just to fill out our knowledge, which perhaps isn't as good as if we were in New Zealand, about how you would characterise the Treaty of Waitangi and why it's been necessary or appropriate to develop these principles.
Right. So this is a little complicated, and I'm assuming little knowledge in the room. Some of you may know much more than others. But so the treaty was entered into between the British Crown and 539 of the leading chiefs of the country in 1840. It's in two languages. They are not translations one of the other, and this is problematic. The English text transfers it's a treaty of cession, transfers sovereignty to the British Crown. Her Majesty Queen Victoria, freshly on the throne, in return for Her Majesty promising to the chiefs, tribes and individuals of New Zealand at the time exclusive and undisturbed possession of their lands, forests, fisheries, and such other possessions as they may such other properties as they may individually or collectively possess for as long as they wish to retain the same. That's Article 2, and Article 3 says, and these Māori shall have all the rights of British citizens, rights and privileges of British citizens. So actually quite a forward-looking document, clearly a product of its time, the post-abolition period, the rise of the evangelical missionaries and human rights consciousness in the middle of the 19th century. So real estate rights and equal rights in return for giving Her Majesty sovereignty. The Māori text does not say that.
Does not say the sovereignty bit.
It says, well, of course, because sovereignty is such a culturally freighted word, right? And when you're talking about sharing of power across cultures and legal cultures in particular, you're bound to run into problems. So the Article 1 of the Māori text says, ka tukua ki te kuini o ingarangi te kawaratanga katoa o rātou whenua o rātou kāinga me o rātou taonga or something like that. O rātou whenua. Anyway, it is given up to Her Majesty the kawanatanga of their lands. Te kawanatanga katoa, all of the kawanatanga of their lands. Now, kawanatanga is a transliteration. The base word is kawana. If you think about it, you can hear what it is. Governor. Tanga turns governor into governorship. The second article, I know this is complicated, try and stay with me. The real estate guarantee says, ka whakaritea ka whakaaetia ki ngā rangatira me ngā tāngata Māori katoa o New Tireni, te tino rangatiratanga o rātou whenua, o rātou kāinga me o rātou taonga katoa. And in return, Her Majesty guarantees the tino rangatiratanga of their lands, of their villages, and of all their treasured things. Tino is an intensifier, so very, or lots of, or something like that. It's hard to translate it directly into English. Rangatiratanga, the base word is rangatira, which means chief. The tanga turns it into chieftainship, or the authority of the chief. So, what's guaranteed is not real estate rights in the Māori text, but self-government. There's no doubt about it, really. It's not a radical proposition. It's pretty orthodox. And then the equality rights are the same in both languages. Now, the reason that these are controversial and different is, I don't know if we've got time for this, but it's kind of interesting. The kawana is first used in the Bible, in the translations of the New Testament. So the missionaries sat down with the Māori, the experts and Māori chiefs, to work out how they would translate the four Gospels, first of all, and then the Pauline books.
This is before the treaty.
The missionaries turn up in 1814. So between 1814 and 1840, the four Gospels are drafted. They needed a word for Pilate. He was the kawana, the governor, right? So it's clear that governorship, kawanaship, was an important power because Pilate was not an unimportant man. Roman imperial authority was rangatiratanga. So that gives you a sense of the relationship between the two. If you know anything about, if you're Catholic, the Our Father, or if you're a Protestant, the Lord's Prayer, Thy kingdom come in Māori is kia tae mai tau rangatiratanga. So God's kingdom is rangatiratanga. So you get a sense of what's being kept and what's being given up. Pilate is an outsider exercising some administrative function, but the sovereignty remains with the chiefs, right? Actually, although these things appear to clash, they don't really clash in reality, because in almost every British colonial context, there is an acceptance that authority remains with the indigenous nations at the point of colonization. North America, the US and Canada, New Zealand, and actually in the early context of Australia too. It's just a fact, because the state has no arms and legs at the point of colonization. It takes a long time to get them. So it's not that radical an idea that you would recognise that authority belongs somewhere else at the point of contact. Anyway, so that's now the principles.
Yeah. So when the courts came to have to look at all this, how did the principles come about?
So the advisors to the politicians and the politicians themselves and the historians all knew that these two texts were not translations one of the other, and that they had to work through the conflicts within them if there were such conflicts. And so the Parliament coined the phrase, the principles of the Treaty of Waitangi, to avoid requiring the tribunal to have to unpick an unpickable document, to try and get to the heart of the thing in the case of conflict or a reading of conflict. Hence the principles of the Treaty of Waitangi. And they have tended to animate the law about the treaty ever since, not just in the Waitangi Tribunal where the phrase is first used, but much more generally now.
Okay. So when people have been either through the Waitangi Tribunal or have gone straight to the Crown to negotiate a settlement, can we just talk a little bit about what those settlements look like? And then I'm going to come back to another question about a comparison. But can you give us an example of what those settlements look like?
So what in Aotearoa we would call a treaty settlement, here you would call a treaty. You can't call it a treaty settlement back home because there's a treaty and it has a sort of sacrosanct nature, so no one's going to,
create another one.
No one's going to dig around that thing. So they get called treaty settlements. You have a deed of settlement that is implemented by legislation. So every settlement has legislation, and it will cover They're all different and they reflect the needs and drivers of the particular community that is being negotiated with. Some are heavy on some aspects, some are heavy on other aspects, just because that's what the community tends to want. So there'll be a value attributed to the settlement. There'll be what's called cultural redress, which relates to sacred places, often relationships with rivers, mountains, national parks, that sort of thing, that have given, for the purpose of the settlement, a zero valuation. There'll be what's called a post-settlement governance entity created, sometimes in the statute, sometimes separately from the statute, but reflected in the statute, which becomes the governance body for the post-settlement tribe. Sometimes you'll have partnership directives. For example, a directive that the Department of Child Welfare, Oranga Tamariki, must meet with the tribe for the purpose of building working partnerships with respect to the welfare of their children on an annual basis. They'll have the same requirements with local authorities, and often they'll say, for the purposes of the local authority, the statute will say, these are the traditional owners, you must work with them in terms of the environmental regulation requirements under what we call the Resource Management Act. So what they do is build requirements, build the infrastructure of requirements for partnership with officialdom at various levels, usually with the social services agencies, child welfare, social welfare, often conservation, because conservation lands are often very important to tribes, sometimes fisheries, so on and so forth, depending on the... So what you get is a statute that creates a capital sum, locks into the law cultural relationships with particular places, establishes a governance entity or reflects a governance entity that's been established by the tribe itself, and recognises its mandate, ratifies its mandate, and creates the sort of bridging infrastructure with officialdom.
And the value component, are there different approaches to how that's calculated?
So this is probably the most controversial aspect of the treaty settlement process. When the policies around that were first dreamt up in the early 1990s, so you can see that the tribunal had been active for about half a decade, and it became clear that coming down the motorway towards the government was a whole pile of tribes wanting to negotiate reparations for the claims that were going to be upheld by the tribunal. Everyone understanding that colonisation had occurred in ways that injured Indigenous nations and in ways that were routinely and uniformly in breach of the principles of the treaty. So this was everyone understood that, including the Crown. So they built policies to respond to that. What were we talking about?
Value.
Value, yes.
In a nutshell, because I want to push on to a couple of other things.
Fair enough. She's the Chief Justice. So in 1992, they came up with this thing called the fiscal envelope, which was that claims would be capped. The value of claims would be capped at $1 billion in 1992 value.
For all claims?
All claims. There was no particular science behind the number. It was just a number that Treasury felt was affordable, and the politicians felt they could sell to the public. That meant that the settlements were all cutting up that pizza across the next 30 years. It became very clear within a decade that $1 billion wasn't enough. And luckily, the two bigger tribes that settled early, Tainui, who suffered under the confiscations following the land wars of the 1860s, and Waitaha, the big South Island tribe that lost most of their land by skullduggery, to be fair to everybody concerned, in the early period of colonisation, inserted into their settlements a ratchet clause, which said, we get, each of us, 16 in one case and 17% in the other, of the final value of the overall settlements. So that protected them and allowed them to be first movers without risking, basically, on reflection, getting ripped off, if you see what I mean. But even with that, the cap has tended to place downward pressure on values, and claims in New Zealand, reparative claims in New Zealand, tend to come to about between 2 and 5 cents in the dollar. And that means the capital sum for tribal reconstruction is small. And unless the tribes find ways post-settlement of leveraging that capital sum in a way that allows them to touch the lives of their people, the great risk in this experiment is that the new tribal entities will lack the ability to be relevant in the lives of their people. And if that becomes the case, the settlements themselves will fail. So that's a genuine risk that everyone's very much aware of now.
You have a nice way of describing the fundamental difference between what groups in New Zealand have to prove under the Treaty of Waitangi settlement processes and what groups have to prove in the native title process here. Can you just share that with us?
Okay. Here, if you're going to win in the native title court, it seems to me, you have to convince the judge, you the claimant, have to convince the judge that colonisation didn't hurt.
Because? Because
if it hurt, the more you lose. Right? So you're focused on continuity, on being able to shake off the bruises. The more you shake off the bruises, the more exclusive title you get. Right? That's how Aboriginal title works everywhere in the Anglo-Common Law world. It's no different here. Aboriginal title or native title is not a big thing in Aotearoa because title was recognised early on in the colonisation process. It couldn't not be. The tribes were too well armed. So what happened was, over a period of about 30 or 40 years, a system was constructed to allocate titles and individualise them, and to get at title very cheaply that way. Worked brilliantly, utterly in breach of the principles of the Treaty of Waitangi, as the Tribunal has said repeatedly, as the courts have said repeatedly. This is orthodox legal principle now. So, in New Zealand, the approach is the opposite. Your job is to convince the judge, the Waitangi Tribunal judge and panel, that colonisation was the entire problem. That your existence is an existence of victimhood, and colonisation was the cause of all of your woes. The problem with that is, of course, it tends to extract agency and therefore dignity. The problem with native title is it tends to accentuate agency and ignore victimhood, because it has to. So I've long thought that the best system would be one that locked those two together so that everyone could tell the truth about choices that were made by Indigenous people and choices that were made by the colonising governments that led to their downfall, the downfall of the Indigenous peoples. And you could be serious and honest about what you're trying to achieve with the post-colonial reckoning.
Which, as I understand some of your views, you see as needing to be much broader than property rights.
Yeah, well, that's true. I don't want to be wagging my finger at the Native Title Court.
No, don't do that.
But the problem with...
But I guess let me explain a bit more. What I'm interested in having you explain to everyone is this notion about partnership and about treaty settlement processes being more holistic,
constructive, yes,
and constructive and forward-looking, including regeneration of culture and language and pluralism, and not just being about figuring out title.
So, yes, the problem with the idea of Aboriginal title is that its whole purpose, this is everywhere, it applies as much to New Zealand in respect of the areas where Aboriginal title still applies as it does to here and to Canada where it still applies. Its purpose is to assimilate Indigenous notions of relationship to culture and resource into a property-based system. The job of the judge is to look at the evidence and say, that looks like property. Good, here you have a title. So it is, at its essence, assimilative, because property is a deeply cultural idea that those of us who trained in Western law have forgotten. It's not the given. It's the way, it's water for us Western trained fish. And so we don't see it. But if you were to ask my ancestors 200 years ago whether they had property in that land or that river or that mountain, they would not understand what you were talking about. And that must be 1,000 times more so here.
Well, so, I think, as I said to you, what we often hear in evidence is that people say they belong to the country.
Yes, that's right. And it's the same back home. There's one of the more famous treaty settlements more recently is the Waitangi River settlement, which recognised the legal personality of a river, right? And their famous saying is, "Mai te kahui maunga ki Tangaroa, ko au te awa ko au," from the family of mountains in the centre of the island all the way to the sea god, I am the river and the river is me. Because they see the river as their ancestor. They talk to the river. They say, I have obligations to you, river, and you have obligations to me, river. Right?
And this has been recognised now.
Sure, yes, this has been recognised in a rather cool way because it's been recognised in a partnership structure, so that it's not just the traditional owners who are the guardians of the river. They insisted that the Crown be a partner, that the Crown be in the game with them and change its view of how it saw the river. And they insisted that they have policy and decision-making structures below that. The Māoris insisted this. It reminds me a bit of the Uluru Statement, really, the kind of generosity of it. I'm not sure I'd be capable of that generosity, but the farmers are all there, the tourism operations are all there, the local authorities are all there.
You mean within this concept, who are the guardians?
Not within the concept of the hood, so that the guardians are Māori and the Crown, representative from each. Below that are structures to build policies and laws in respect of the administration of the river. Those, the local Māori insisted, had to represent every stakeholder in the community and in the economy, not just Māori, even though they were the only ones to say, this river is my ancestor, okay? And they saw that as a way of teaching the others that there's another way of thinking about this and perhaps counter-colonising their minds.
And what have you seen on the uptake in this?
So
there are a couple of examples of this.
There's the Urewera Forest, yes. Same sort of idea, although it's a national park, so the competing stakeholders are fewer. It's basically just the Crown and the local traditional owners. But the model seems to be working fine in both cases. The point I was driving at is that these things are trumpeted around the world now as groundbreaking. Finally, the law recognises that the environment is alive. The thing is, in Māori custom and tikanga, this is, it's orthodox. It's like property, right? So you've got this system that, on the one hand, is relationships between people primarily defined by contracts, entered into freely by autonomous individuals or groups of individuals. And their relationship with the planet is primarily framed in terms of property, right? Then you've got this other system in which relationships between people are primarily defined by kinship, what we call whanaungatanga, and the relationship with the planet is also defined by kinship and the obligation of kaitiakitanga, the obligation to nurture one's own, right? You've got property and contract here, and you've got kinship or relationship to country if you're from here, right? And so you're saying, you take relationship for country and make me some property, please. It's a good way of developing an exchange currency, but it's fake in truth. The challenge is to see country in a different way, to understand that property and contract are themselves contingent, that they are not givens, and that there are plural ways of thinking about these things that can inform our own assumptions. And the people from Whanganui and the people from Te Rewera have forced the other side of the table to start to think in those terms, albeit at the margins now, but it does seem to me, sounds a little Pollyanna-ish, and maybe I'm overstating this, but it does seem to me that the inroads are running deeper as time goes on.
So are you optimistic that treaty settlements are capable of introducing this pluralism in a tangible way? These aren't sort of isolated examples, that's a process, a settlement process that's capable of introducing pluralism. Well, that seems to me to be what you're saying. And is that related to the way that tikanga has also been adopted more?
Yes, I have to say, if I were a gambler, I'm not, at least in the few occasions I've tried, it hasn't worked out well. If I were a gambler, I would say this will fail through lack of imagination. It's failed often in the past. And for it to succeed, people in key positions need to have more imagination than they have now. But the sparks are still there. And some changes have occurred that, in my view, are profound enough for me not to think there is no hope. Rather, for me to think that well stewarded, well curated, well nurtured, this process of change that my country is in the middle of and your country is in the process of too, in fact, done well, can produce a system of law and values that is better than both of the other two put together, that is mutually informing.
So can we stay with this? You use the word hope, so let's stay with that for a moment. And I want to go to another metaphor that I've heard you use that I just think is lovely, that I'd like you to share. So one of the challenges for Aboriginal and Torres Strait Islander people here when they get a determination of native title is whether they are equipped to deal with it, and equipped in the broadest sense. Are their communities able to deal with it because of all the challenges they face? Are they properly resourced? All those sorts of things. We are dealing often with communities that suffer under a lot of disadvantage in various areas. And you were describing to me how Māori communities often face the same kinds of issues, and you had this great metaphor about a car that was still going, and that's the hope bit. So can you tell us how you describe that?
Yeah, I hope it goes down well. It's a little edgy. I think that I'm both a member of an Indigenous community, and I've worked with Indigenous communities as a lawyer and as a judge for my entire career, really. And so I've seen community transformation both from the inside and from the outside. I've seen it warts and all. There are plenty of warts, both within my own community and with the communities with which I've had to work. And I think the way to think about it is that if these communities were cars, we celebrate the fact that they're still running, because a bunch of people spent a long time and a lot of resources to try and stop them running. But boy, are they banged up. And it's going to take some time for the dents to be worked out and for the broken bits to be fixed. It's not going to happen quickly. It can't, because the damage is there for all to see. So it would be wrong for us to create this kind of Disneyland picture of the noble savages becoming liberated, blah, 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 which is often tempting because that would be great if it were true. In fact, there is so much healing required in communities that we, the judges, we, the lawyers, we, the people that just know, need to help with however we can, because the result, if it works out, will be enriching for all of us. So what's the point in these processes, whether they're native title process, treaty making processes, treaty settlement processes where I come from? What's the point? And it seems to me, the one insight I've had in my years working in this area is that the point is reconstruction. You see, before those who would undo these communities because it suited the colonisation agenda, before they came, if you were to ask individual members of these communities what were the most important institutions in the communities, they would say it was the tribe. It was the community, led by elders who owe me obligations, who support me, who give me resilience, blah, blah, blah. If you were to ask those same people today, they would say it was my employer and the state. That's the vast difference. If they've got a job, the most important person, the institution that impacts me in my life most powerfully right now is the person who pays my salary. Thank you, Your Majesty. And the state that provides me with hospital care, law enforcement, stops my children from being hurt if I'm behaving badly, etc., etc. All of those roles traditionally were performed within the community by people who were relations of those being supported.
And it's possible to reconstruct.
Well, it's not possible to go back to that, but the decolonisation process cannot succeed unless a key result of its processes is the recentering of the tribe and the lives of their people in a modern context. Now,
is that why partnerships matter so much?
Yes, I think it is. You see, anything, it's one thing to say that, what we've got to do is raise the average income of Māori, for example, to the average income of everybody else, and then everything's fine. Well, it's been tried for a while. It hasn't actually worked. And it hasn't worked because the fit hasn't been right. And I can tell you that from personal experience, both within my family and in my own personal life. And what we know is that in my country, Māori children who grow up speaking Māori and connected to their community do not commit crimes. Go to universities, become professionals or carers, or perform important functions in their communities. Not just occasionally, every damn time. The statisticians tell us, right? So there's something about community cohesiveness that creates resilience. So that when the times get tough, as they will for all of us, those tough times can be withstood. Community is, for all humans, utterly key to that. This process is really about trying as hard as we can in a contemporary context to reconstruct community, to build back resilience so that cultures, languages, and communities can not just survive, but thrive. And that's really the experiment we're in now. Partnerships with the state are one way of building back that community resilience and cohesion. And at the end of it, if it works, you have this pluralist reality that I think we're seeing the beginnings of it now back home. Everyone buys into. Everyone feels like they've got a piece of it, right? And you see that here too. The welcome to country, which kind of gets trotted out with what might be said monotonous regularity, is a really powerful thing, because it's right off the bat saying we acknowledge that there's something before us and that we're here as their invitees. Well, 20 or 30 or 40 years ago, it's unthinkable, utterly unthinkable. So that gives me a sense that the journey that's going on here is exactly the same as it is back home. And the progress through it comes to be seen, at least I hope it'll come to be seen, as producing a result that makes everybody feel they've got a deeper investment in country than they had before it. Because they'll see there's another reality than property. There's another reality than individual freedom. There's a reality about community, about mystical connection to land, that even if they don't belong to it, they can see it and share in it. And that makes New Zealand a place in the South Pacific in the way that would make Australia, I guess. And that's, to me, that's the win-win out of this. You hand over the resources and that power, and you get back this magnified enrichment for all. Boy, that was a political speech, sorry.
That's a good point. Can we just thank Joe for his thoughts so far, and then I'm going to invite some questions. Thank you, Joe. All right, who's going to be brave and ask the first question? It's always the hardest one, the first one. Someone has to break the ice, otherwise I'll pick someone. No, I won't.
Yes, you will.
Thank you. Thanks so much for your conversation so far, Joe. I'm just curious about your comments around building communities and resilience. Obviously, in Australia, we had the opportunity to do so with policymaking around the voice referendum last year. I'm curious as to your experiences in the role of law in building that community resilience in Aotearoa, what with the use of tikanga in colonial courts, and whether that's an avenue that Australia can pursue as well.
Yes, good question. So it's often I've noticed this a lot in Australia that people that know a little bit about what's been going on back in New Zealand think it's this amazing thing has happened because the courts have recognised tikanga as a part of the law. And while I'd love to bask in the glory of that, it is really a misdescription of what has happened for the last 30 years, since 1975, for the last 30, 40 years. The legislature has enacted measure after measure that incorporates tikanga into the exercise of public power. First in the area of environmental law, then in child welfare law, then in criminal justice law, then in intellectual property law, trademarks and patents in particular, then in the administration of the conservation estate, which is a third of the country, and so on, the administration of the coastal marine area. These things became just the normal way in which you reflected the multiple dimensions of the country, not because the judges say it, because the legislators said it. And at some point, you must get to a tipping point, right, at which it becomes so normal, the common law has to respond. That's really what has happened. Here comes a little speech, but I once did an investigation into when it was that the New Zealand national anthem came to be sung in Māori as well as English. And it was at a rugby league test in Auckland where the Kangaroos kicked our butts again. Rugby league is very much a working class game in my country, very brown, audience, if you like. And then netball followed, then hockey followed, then soccer followed. You know the story, rugby being the conservative sport that is, went last. No one commanded that. No government entity said from now on you will sing the national anthem in Māori and English. When I was a kid, I didn't even know there was a Māori version of the national anthem. God of nations, at thy feet, in the bonds of love we meet. As a kid, what the hell, I don't know what that meant. And then they started saying, E hoa atua o ngā iwi mātaura. Off it went.
So it's not just Parliament or the courts?
No, that's so thank you for that. That's exactly the point, that there was this tectonic shift going on about identity, in which ordinary New Zealanders came to see themselves as having some investment in the Māori dimension of the country, albeit full of controversy and friction. Yet, how the hell did they decide, now we're going to sing this anthem in Māori, stadium by stadium? Now, in a gathering like this, anywhere, private sector, public sector, there would be a mihi at the start, there'd be a song, probably, there'd be a reply.
And
just
the speakers would be sufficiently proficient in Māori to be able to do that, regardless of their ethnicity.
Regardless of, well, you'd hope so. Some of them are a bit...
That's how it looks to, I can say, certainly to judges who travel to New Zealand and see this at events. It looks like there's been a lot of effort put in to being able to communicate respectfully and properly.
Yes. So you get to this point where this is just the way we do stuff. And there is actually, I think, very little difference in the underpinning attitudes of Australians to the underpinning attitudes of New Zealanders. The context is slightly different, and that's helped drive it. A decade ago, after a Pākehā judge, a European judge, said to the Chief District Court judge, why don't we open our courts in Māori as well as in English? So the courts are generally opened. Silence will stand for Her Honour the Judge. Silence for Her Honour the Judge, please stand, or something like that. I'm not used to hearing it in English anymore. And they added, kia rite mo te kaiwhakawaia tūkoa. The Māori equivalent of that, right? And all the courts picked it up. No law change or anything, they just decided it was a good idea. Although the Chief Justice at the time thought it was just virtue signalling and far too symbolic and far too empty. Then the Crown lawyers, appearing before the courts, usually in criminal matters, because they were a government department, the Crown Law Office, thought as part of the, cultural sensitivity stuff that the public sector is really good at, they would ask the judges if it was okay to introduce themselves in Māori. Tēnā koe te kaiwhakawā, ko Williams taku ingoe tuanau mo te karauna. Morning, Your Honour. My name is Williams and I appear for the Crown. And that annoyed the defence lawyers, who often were acting for Māori. And they thought, this is just a cunning trick to undercut my moral position. So they decided that they would learn to do it too, right? Then I started getting calls from judges saying, look, we're opening these courts in Māori. Counsel on both sides are introducing themselves in Māori. I kind of feel like I should say something. So I would give them lines to say, Morena e ngā roia nau mai i te kōti pira. Morning, counsel. Welcome to the Court of Appeal. And as a young judge in the Court of Appeal a few years ago, the junior judge in a 3-judge panel, I sat down, routine criminal appeal. Kia rite mo ngā kaiwhakawā of te Queen ia tūkoa. Silence will stand for the Honours of the Queen's judges. Tēnā koutou e ngā kaiwhakawā, ko mea taku ingoe tuanau mo te karauna. Greetings. Good morning, Your Honours. I appear for the Crown. So on and so on. Judge says, Morena, i ngā kaiwhakawā, nau mai te kōti pira. Morena e ngā roia, nau mai te kōti pira. Welcome, counsel, to the Court of Appeal. Now, I'm translating for you. There was no translation. I'm the only judge in the court who speaks Māori. I'm the only Māori in the court. I haven't said a word. And almost no English has been spoken for the first 5 minutes of the court. And I thought, yes. Because here's the catch. In 1978, a judge said to a criminal defendant who wanted to run his case in Māori even though he could speak English, that he could not do that, wrote a judgment that said that the language of the courts in New Zealand has been English since 1362. It was interesting to my ancestors who were in Aotearoa in 1362, but based on good British history and principle. And I thought to myself on that day when I first saw this happen, that no bench doing this would ever have found that. So that the interesting thing is when the Māori language walked into the courtroom, something more came with it. It wasn't just an empty symbol after all. It changed the flavour. It changed the culture of the place. It became much harder for judges to ignore cultural difference because they were purporting not just to acknowledge it, but to celebrate it in these beginning rituals.
And that remains the case, those rituals.
Oh, yeah. Oh, you should have seen the swearing in. Yeah, you should have seen the swearing in of the Chief Justice. It's fantastic. the court basically got taken over by Māori ceremony. And here's the thing, half of the people performing the ceremonies weren't Māori. We have a choir that sings at swearings in now. They're made of what you would call the judges' associates, what we call the clerks. Blonde-haired, blue-eyed boys and girls. Karanga tiara, hiawehi, karanga tiara. They love it. And the people who come along to the swearings in love it too, because it's New Zealand, right? It's not England.
You have singing at your swearing in?
Yes, we have singing with a...
That might be a novel proposition for Australian lawyers to digest.
Well, not only do we have singing at swearings in, there's a song of welcome sung by the group of people. There's a karanga by the senior woman, not the judge, the senior woman within that group, who may or may not be Māori. Then they sing the song of welcome. Then everyone sits down. Then a judge will stand and formally welcome everybody in Māori before the Chief Justice speaks. And that's done in all the courts now. Whoever the head of bench is waits for that formal greeting. This is a relatively new thing, but it's become required. And it has made people happy, even conservative people, because it says something about the identity of the place. It is distinctive, makes us different from the places we came from, or it makes us better reflect the various places we came from.
And the place we are.
And the place we are. That's right. So that's, now you were asking about tikanga. These underpinning things undergird the acceptability of a common law judge saying a principle of the common law in tort or appellate procedure can be held up against the light of tikanga as well as the light of English or Australian precedent.
Now we have to be careful not to get in. We could talk about tikanga for another hour now.
Yeah, I know, sorry.
No, don't
sorry
be
about the
sorry.
speeches.
No, sorry. And this has been fantastic. We're just on time, but I think we
there was
have
a question.
One other question. Anne, was it you? Or yep. Can you remember it?
Yeah, sorry.
That's all right.
It's hard to shut me up.
I was going to ask for an invitation to comment on two things. One is Māori in the judiciary. The other one is about the role of women in the settlement discussions that you were talking about. And I just make the comment that in terms of what was proposed, so far as the Voice to Parliament was concerned, in Australia was equal representation of men and women. Of course, that's all history in Australia, sadly now. But I was just wondering if you could tell us your reflections upon how that's looking at the moment.
What was the first one?
You mean proportions, numbers?
Yes. So up until very recently, the numbers of Māori in the judiciary was relatively low. That has changed radically in the last 5 years. So there's one Supreme Court judge, one Court of Appeal judge, 3 High Court judges, 50 District Court judges, 1 Environment Court judge, 1 Employment Court judge. This is a small system, not much bigger than Victoria, so that'll give you the sense of scale. The Chief District Court judge who drives the appointment of family court judges, district court judges, youth court judges is Māori, and decided that what he wanted to do was to make the district court bench, including the family court in our country, better reflect the community. And boy, has it made a difference. someone asked me in an interview a long time ago, if you have more Māori judges, is that going to change the system? And my answer was no, but it helps. And we see that now all the time, the level of comfort with more pluralistic ways of dealing with criminal justice issues and family issues in particular is often driven by Māori members of various common rooms with the support of their non-Māori colleagues, particularly with the support of their Pacifica colleagues in the Northern North Island in particular. So numbers really count. And if anyone's interested, we've decided that we're going to run an International Indigenous Judges Conference in New Zealand next year. And we've invited Australian and Canadian judges and American Indigenous judges to come join us. I know that sounds very narrow and Anglo-American common law, and it is, but only because of scale. We needed to get this first one off the ground and running, because if we went any wider, it'd be too big. Anyway, so what's clear is that here in Australia, back home in New Zealand, in Canada, and we think in America, though America is a bit opaque, there is such critical mass that it would be good for us to come together to think about, can we deliver Indigenous justice as Indigenous judges, if you like. So that's that.
Now,
the role of women?
You got like 2 minutes because we should have finished 10 minutes ago.
Oh,
so,
sorry.
No, but it's good. It's because there's so much to talk about, right?
You're very kind, Chief Justice.
So Anne's question is, I think it's a suitably provocative question about the role of gender in, if I'm right, in negotiations.
Well, the settlement process is tribe by tribe back home. There is no nationwide settlement process except on fisheries, and that was a long time ago.
But are there issues about who's negotiating from the tribe?
Well, I can tell you, and I don't, Gillian, you can tell me if you think I'm not being fair. Women run the Māori world. They're the bosses. Ask my daughters. And they take up leadership roles with alacrity. And there's still plenty of men involved too, but a lot of the leadership, particularly the practical get-it-done leadership, is provided by women, not men. And if we were to, one, let me say this, there's no chance a voice referendum would have succeeded in New Zealand. Two, if there was going to be a proposal put up that said that, I don't think people would be talking about gender equivalence, not because gender equivalence is not an issue, but because if there was to be gender equivalence, it would be the men saying, can we get a seat? Maybe I'm overstating that, but you look at the Māori politicians in the parliament, most of them are women.
All right. I think we're going to have to stop there, although it's pretty obvious we could keep talking. Joe, thank you so much for sharing your insights and doing so honestly, which is one of your trademarks and something that I really admire. So thank you for being with us and teaching us and sharing those views. Can you show your appreciation? Thanks, everyone. Thank you very much.